All right. Good morning, good afternoon, good evening, whatever is the correct time of the day, wherever you are. Thank you for joining us. If you have joined us before, welcome back. And if this is your first time, welcome. And I hope you like what you see. We've got an excellent presenter this morning, very knowledgeable, and he is going to be answering your questions on determinations. And before we get started with that, I'm going to give a quick whirlwind introduction of the ICCP. If you've been here before, you know I don't like to waste any time. I like to get you straight into the presentation. So with that, let me just share my screen. Okay, so who is the ICCP and what do we do? The ICCP is a professional members organization that recognizes those with the skills, qualifications, and expertise in the management of construction claims. We have three primary objectives, and that is to establish international professional standards, to give recognition to those who meet those standards, and to help and educate those who wish to gain the experience needed to appropriately manage claims. And why is there the need for the ICCP when there are so many construction organizations out there? Quite simply, construction claims have become a key part of the international construction industry. And people come into construction claims from many backgrounds, from quantity surveying, engineering, project management, even construction law. And they deserve recognition for what they do in construction claims. And until the ICCP was established, there was no institute that specifically recognized those with the specialist knowledge that it takes to appropriately manage claims. Okay, so I will quickly introduce our steering committee. Sorry, I need to add two pictures to this. My apologies, but you may notice one very familiar face there, Daniel Alcon. He will shortly be answering your questions. He is one of 5 elected members, and we also have an elected president. Okay. In terms of membership, we have 3 regular levels of individual membership. We have associate, member, and fellow, each of which has their own criteria for achieving. We also have special levels of student member and graduate member for those seeking their initial construction qualification. And we have corporate membership for companies and departments that specialize in construction claims. Okay, and what is in it for you? What do the members get out of their membership? Well, we offer a private members area, which has a collection of articles, papers, research, etc., in our knowledge bank. We have a collected listing of higher education courses. We provide listings of further training opportunities like CPD. We also have a bookshop, which does not sell books, but does offer reviews of the latest releases. We have a library of practical templates to help our members not only save time, but also ensure that their claims are completed to the highest standard. We offer regular CPD opportunities like this one. So everyone was free to join this webinar today. It was open to the public, but a CPD certificate is a benefit of membership. We also have the ICCP Academy, which is an irregular sessions that are more technical in nature, and those are not open to the public. Those are for members only. We also offer discounts on books and training with Wiley, Blackwell, and Rutledge, as well as our training partner, Claims Class. We have a monthly newsletter to keep members and non-members up to date on the latest in the industry. We offer industry exposure in the form of a public listing of our members, as well as certificates and logos of membership. We have a private LinkedIn group where members can discuss their contracts and claims questions with other professionals, get the advice of their peers and seniors in the organization. And we have the optional benefit of the Register of Claims Practitioners, which is popular with our consultant members. So each of those claims practitioners has their own webpage, and it helps increase their online profile. I realized that was very quick. And if you would like more information, if you requested more information when you registered, I will be sending you an email in the next few days. Otherwise, please have a look at our website, instituteccp.com. You can also email Paulina Ganeva at her email address there, and membership@instituteccp.com for all membership inquiries. And with that, I would like to hand over to our steering committee member, Daniel.
Okay. This is just basically, as was written in the invitation, the subject today is Sub-Clause 3.5 determinations of the 1999 FIDIC Red Book, of which I wrote an article some years ago, and I believe that was included in the invitation. But obviously, as you're probably all aware, since the issuance of the 1999 FIDIC suite of contracts, there had been another issue in 2017, and actually a reprint in 2022. Both of which changed Sub-Clause 3.5. So I'm just going to briefly go through this and explain what the changes were. Webinar, there's two sections. There's FIDIC 2017 update and FIDIC 2022 reprint dates. So going to the FIDIC updates first. The new in the 2017 edition, there's a new Sub-Clause 3.7, which was previously 3.5. The engineer has to act neutrally and shall not be deemed to act for the employer, which was the case under 99 FIDIC, although neutrally is not defined. Consultation, consult promptly jointly to endeavour to encourage parties to agreement. If that's reached, write it down and the parties to sign within 42 days or proceed to make a determination. I'm just going to quickly rifle through these. So make a fair determination, taking account of all the relevant circumstances within 42 days. If the engineer does not issue a notice of agreement or determination, the claim is deemed rejected. Or the matter, which is a new thing in 2017 FIDIC, is deemed to be a dispute and may be referred to the DAB. A no notice of dissatisfaction is required. And then moving to the next slide, agreement and determination under 3.7 also applies to measurement of the works, rates and prices, variations, extension of time and adjustments to the contract price and schedule of payments, day work, amount to be paid for plant and materials off-site, amount not certified in an IPC, and disagreement as to the cause of the defect. If you've read my article, you know that under 99 FIDIC, it applied to a lot of 3.5 applied to a lot of clauses where it clearly expressly stated that Sub-Clause 3.5 should be followed, and to some others where it was implied rather than stated. So this is perhaps more specific. The engineer's role in dealing with the parties' claims and with other matters under the contract is set out in greater detail in the 2017 FIDIC, using a step-by-step procedure with time limits. That was a criticism of the previous edition under what is now 3.7. So consultation with the parties, that pretty much repeats what was written above. So I'll move away from that. And then finally, this is just a general note from the author of this, which is Fenwick Elliott. In order to promote what is expected of the engineer under this subclause, namely that she deals with parties even-handedly in trying to broker an agreement between the parties, and if there is no agreement, in coming to a fair determination of the matter or claim. It is now expressly stated that what was implied under the 99 book the engineer is required to act neutrally between the parties and not be deemed to act for the employer, as was stated in 99 FIDIC. To avoid the problems that many users have reported to FIDIC in recent years, it is now also expressly stated there should be no requirement for the engineer to obtain employer's consent before exercising his or her authority under Sub-Clause 3.7. And then more recently, this FIDIC 2022 reprint, some updates. There's one major thing, and that's that the 2022 reprint has introduced a distinction between a matter to be agreed and determined and a claim. This has been done by excluding a matter to be agreed or determined from the definition of a claim, and instead listing specific sub-clauses that refer to a matter to be agreed or determined in Sub-Clause 3.7a of the Red Book. And with the introduction of this distinction, the definition of dispute now includes a claim with a capital C and other matters to be agreed and determined. And the new definition now also requires a party to give notice of dissatisfaction with respect to the engineer's determination for it to constitute a dispute. If you read my article, you know that establishing a dispute is very important in this type of situation. Otherwise, there's a danger that if you go to arbitration, the arbitration might be thrown out if no dispute was established. That's just a fundamental requirement of any alternative dispute resolution. So unless an express exception applies, an agreed party can no longer refer a dispute directly to the DAAB without first issuing an NOD. So questions?
The first question is the engineer's determination fixed, or can it be changed if further details are later provided by any party?
Under 1999 FIDIC, I think I said in the article, it basically, the determination, all the determinations are not final. They're basically open. So the FIDIC didn't write this in the contract and maybe addressed in the 2017 version, but basically they considered that the discussion and determinations under 1999 FIDIC they were a sort of series of discussions. Nobody expects to be able to go to and immediately resolve the problems, because that's totally impractical. Because Sub-Clause 3.5 basically requires the two parties to meet and discuss with the engineer. And very often the employer is maybe a committee. I worked on a project in Qatar where the committee was basically the prince, so the head of the committee. So you wouldn't expect him to be able to turn up at every meeting. Therefore, it was quite normal for an engineer maybe to discuss matters of the contract and then possibly organise a meeting with the employer. So FIDIC had they didn't mention the contract, but in their guide, they basically said that it was a continuing rollover process. So there could be the determination could be reopened. Actually, my personal opinion is that is a little bit causes a problem in itself, because you'd expect a determination to be final, but apparently not.
It's not over till it's over.
Yeah.
All right. The next question submitted in advance was, the contractor's claims have a time period of 42 days to respond in Sub-Clause 20.1. But for employers' claims, there is no time in Sub-Clause 3.5. Kindly comment.
Yeah, that was a problem. There was in the 1999 FIDIC, and that's been addressed in the 2017 version. That was a big complaint. Why the contractor had a time limit and the employer did not. So all I can say is that in 1999 FIDIC, there is no time limit on the employer, but there is in 2017 FIDIC. And as you've probably noticed, if you've looked at 2017 FIDIC, the clause which replaced 3.5, which is actually 3.7, is not 2 paragraphs, it's 2 or 3 pages. So there were a lot of changes and upgrades to the determination clause.
Okay, thank you. And the second question from that person was, Sub-Clause 8.7 restricts employers' claims for liquidated damages against late completion. Does this mean that the employer cannot claim general damages loss of revenue, etc.
Quite sure that's a subclause 3.5 question, but I'm not even sure I know the answer to that question. I might have to get back to you on that.
All right. Yes, that's what happens when questions are advanced, but I think that was received.
But I'm happy. I will answer it, but I'll have to look into that to give you and email you the answer.
Okay, that's great. Thank you very much. Okay, so let's go to the Q&A box. The first question, may you please define matter other than claim?
Well, a matter is one of those things which I listed in my presentation. There were several things listed there, and but matter wasn't really defined in 2017, but in the reprint in 2022, you may recall I read that because of this lack of definition, they've split it in the 2022 reprint and taken matter away from the claim, and they've listed several clauses in the reprint which might cover that, a matter rather than a claim. I mean, there's some people say that determinations are only to do with claims, but in fact, there are several clauses in the 1999 FIDIC which written into the FIDIC Contracts Guide, issued at the same time, they say in there that those matters, even though they don't specifically mention subclause 3.5, it's basically a tool that can be used by the engineer when he has to make an assessment. For example, I think the example I gave in my article was there was a clause for where the contractor had to pay for the power provided by the employer, or vice versa, I can't remember which. And so the engineer would have to have had assessed what those costs were, and so he could use subclause 3.5 for that. So basically, it can be. I think the purpose of subclause 3.5 and latterly 3.7 was to give this tool to the engineer to make a decision about, or for a process to make decisions about things which were undefined.
All right. The next question. How about the Silver Book? Is there any major difference?
The Silver Book. Well, of course, the major difference of the Silver Book is there's no engineer. There's an employer or employer's representative. So, although I based my article on a Red Book, the Red and the Yellow Book are pretty much the same in terms of the wording of subclause 3.5. The Silver Book, the wording is almost the same, but instead of mentioning the engineer, it'll mention the employer or an employer's representative. So, and obviously there'll be certain differences on the Silver Book where, I mean, the employer obviously doesn't have to give himself permission to make a decision, which is a question mark in the Red and Yellow Books. And but I have seen recently in a project I've been working on that the employer, where the subclause 3.5 says that where it says in the 99 contract that the engineer cannot delegate his use of subclause 3.5 to any assistants, in the Silver Book it says that the employer cannot delegate that task to employer's representative. But pretty much apart from that, the procedure is fairly much the same.
Okay, thank you. The next question, what's the legal basis of the engineer's determination and application at law? Can the contractor raise a dispute to the engineer, or should it be to the employer?
Well, I'm not a lawyer, so asking me a legal question is a bit of a problem. I mean, you basically have to follow what's written in your contract. I know that sounds like a cop-out, but the point is, if the procedure says you have to go to a DAB, was basically to get the decision about whether it's a dispute or not, or whatever, then you've got to follow that process, because you'll find probably if you go to law instead of the dispute resolution procedure, depending on what jurisdiction you're in, you may find that your case will be thrown out because you haven't followed what's written in the contract. I don't know if that answers the question, but
okay, yeah. I mean, a contract is a legally binding document. So, all right. Breezing on to the next question, because I know you have a tight deadline. So the engineer in FIDIC 2017 has a wider authority in 1999, as many clauses refer to subclause 3.7. So I think he's just looking for confirmation.
I don't know. I mean, I didn't actually count them, but I do know that in 3.5 there were many. I mean, there were in the 1999 version of subclause 3.5, there were at least 20 clauses which refer to subclause 3.5, and then a further half a dozen which you could argue implied that the engineer should use subclause 3.5 to determine what was written in the clause. So, I mean, I haven't counted the ones in 3.7, so I can't really say if they're more or less. But my guess is there'll probably be more, because 2017 FIDIC was it was noted that it was almost half as the book itself was almost half as thick again as the 1999 book. So I'd be very surprised if there are less.
All right, thank you. Okay, the next question. The employer has replaced the dispute board by the engineer's decision in particular conditions, FIDIC 2010. Is it fair or legal to remove one tier of ADR by the engineer's decision after having determination under 3.5 from the same engineer?
Well, presumably it's saying that that was written in the original contract. So you will have, if you're a contractor, you have entered into that contract and agreed that that is okay because you've signed it. But no, I mean, fair and reasonable is not the sort of expression which doesn't always enter my head when I'm dealing with contracts. Unfortunately, I think FIDIC tries to draft these contracts so that they're fair and reasonable and the risk is balanced. But quite often, that isn't how they end up on projects. And the fact that, but even FIDIC acknowledges that that they haven't actually managed to make it fair, even the original document is fair and reasonable, because I noted when I was reading about the 2022 reprint that some of the changes in there were intended to make it fair and reasonable. So they're continually striving for that, but they don't always attain it. So I think maybe, but if the contract omits something, then there's nothing much you can do. But the only way if you start referring to the engineer omitting something, I don't quite understand that. The only way that anything can be changed in a contract, apart from a variation, which is a different matter, the actual wording of the contract during the course of a project, is if both parties agree to it. So I'm not quite sure how the engineer can do that. He wouldn't have that power.
All right, moving right along then. Can the engineer reject a claim on the basis that conditions precedent have not been adhered to, especially in the context of Sharia law in countries like Saudi Arabia, where entitlement is not subject to conditions precedent, I think?
As you're probably aware, in a common law country, that would be a reason. If it's condition precedent and they haven't complied, it can be rejected because that's what it says in the contract. But in well, not Sharia law, but in civil law countries like here in the Middle East, because I'm actually in Abu Dhabi at the moment, it's very unlikely that a claim could be rejected on that basis alone. More likely, it could be rejected for other reasons, but very unlikely that would be the only reason. In Saudi Arabia, until recently, I think in the last couple of months, they haven't had the same law, the civil law, which exists in the other Gulf countries. So I couldn't tell you about Saudi Arabia because although I have worked there in many years ago, I haven't worked there recently. And I'm not sure of the situation there because it's too new to know. But I imagine that it'll follow the same the same understanding as in the other Gulf countries.
Yes, I've been trying to find someone to present on the recent changes in laws in Saudi Arabia, but everyone is saying, I'm not ready.
Yeah,
So,
exactly.
all right. I know you're on a time deadline, so please just beg for mercy when it's time for you to go. If you've got time for one or two more.
Yeah, sure.
Okay. Interim determination should be mentioned in particular conditions, or the engineer himself can declare it without explicit provision. That's not a question, but I think he's asking, can the engineer declare it without an explicit provision?
I think it's practically impossible to determine. It depends on what the matter is, or whether it's a claim or whatever. But it's practically impossible, as was acknowledged in the FIDIC contract guide, that to actually close a claim or determine a claim in one go, because certainly in accordance with the definition of subclause 3.5, it talks about, and this was an area which was constantly confusing in 99 FIDIC. It says, and I read the clause, it says, whenever these conditions provide that the engineer shall proceed in accordance with subclause 3.5 or determine any matter, the engineer shall consult with each party in an endeavour to reach agreement. So then the question arises, does he consult with each party individually or together? And on massive projects, particularly where as I mentioned previously, where the client is a government department or a committee, as I came across in Qatar, it's almost impossible for the engineer to meet with the client, and so so it wasn't written in 99 FIDIC whether it could be an interim determination or what, but it was acknowledged by FIDIC that they would expect the determinations to be in stages over a long period of time until the issue was closed or the claim was over. So I hope that answers your question.
Could you explain how the contractor can initiate an engineer's determination request? What does he need to follow, or what should be taken into consideration?
Well, it's basically as written in the contract. Wherever the contract has a clause which mentions that the engineer shall proceed in accordance with subclause 3.5 to agree or determine a matter, that's what he has to do, because that's his duty under the contract. Or in the silver one, it would be the employer and the employer's representative. So if you're a contractor and you found that the engineer wasn't proceeding in that way, I'd just remind him of his obligations under the contract, because so those contract clauses, I haven't got one in front of me, but basically you'll find in all those clauses 10.2, 10.3, 10.8, all the whole list of them that are in my article. Basically, you'll find the wording that says that the engineer shall proceed in accordance with subclause 3.5. So, and it says shall proceed, which is quite strong language. It's not optional. It basically has to. So all you can do as a contractor is to remind him of this obligation by writing letters.
The next one is asking for your opinion, I think. FIDIC 1999 allows the engineer to make fair determination in accordance with all relevant circumstances. In this regard, is this impacted in the revised books?
Yeah, it's slightly different in the revised books. Going back in time to pre-1999 FIDIC, in the 87 edition, basically it was understood that the engineer would act impartially as between the parties. And that's mentioned in the first paragraphs of my article. And that's why, but the situation was that the contractor never believed that the engineer could be impartial because he was paid by the employer. And it could be a particular problem if the engineer made an impartial determination, which basically said that the employer was at fault. He might not get any work anymore, or something like that, or that was the feeling. And that's why FIDIC introduced subclause 3.5, but also the DAB. In other words, the DAB would have to make the decision, DAB being formed of parties from both sides, the contractor and the employer, and therefore they would have to make a decision about whether something was a dispute or not, or whether it should, how to go forward. So, and then in the 2017 FIDIC edition, I think that it's been changed again, whereas the engineer was previously stated expressly that he was acting for the employer. They've gone back in a sense to the impartiality by saying that the engineer doesn't act for the employer and has to, I don't remember the exact terminology, but the engineer has to act neutrally. And the only problem with neutrally is it's not defined in the contract, which maybe FIDIC is holding back for its next reprint or whatever, but and shall not be deemed to act for the employer. So in a sense, they've reverted to 87 FIDIC, where it's acting neutrally. I haven't used impartially, but there you go. Okay, I'm afraid I'm going to have to go. Sorry, it was pretty brief.
Thank you so much for these insightful answers and your presentation. I will say, if any of the remaining questions were from members, you are free to drop it into our LinkedIn group. Otherwise, you can drop it into Daniel's LinkedIn group. He has the largest FIDIC contract group on LinkedIn. And I'm sure you can get some great answers there.
Alternatively, what I will do is look at any questions that haven't been answered, and I'll try to answer them. And if we have the contact details of whoever sent them in, then I'll answer them either
certainly
personally or in some way or other. Yeah.
All right. Well, I will do that then. And thank you everyone for attending. If you are a member, you will receive your CPD certificate by the end of the week. All right. Thank you, everyone. Have a great day, and I'll see you next time. Bye.
Thank you very much. Bye-bye.
Thank you. Bye.